compensation, teams, and recovery fund. So in this unit, we're going to cover real estate employment agreements and list their requirements. So this unit is going to cover the following topics: real estate employments, listings and buyer broker agreements, requirements to collect compensation, grounds for denial, suspension or revocation of a license, cooperation with out-of-state brokers, restrictions on compensation, unlicensed assistants, real estate teams, real estate recovery fund. So after completing this unit, you're going to be able to define a real estate employment agreement and requirements for validity. Uh, you'll be able to state the requirements for taking legal action to collect compensation, and you'll be able to list some major reasons for denial, suspension, or revocation of a license. You'll be able to recite the requirements for a cooperation between Arizona broker and an out-of-state broker. You'll be able to discuss who may legally pay and receive compensation for real estate services and the penalties for unlicensed persons who receive compensation. You'll be able to list what unlicensed assistants may and may not do. You'll be able to define real estate team and describe the process for obtaining settlement from the real estate recovery fund. We're going to discuss ARS 32-2151.02, which states that an employment agreement is a contract hiring a broker to buy or sell real property for compensation or commission. Both the listings and the buyer broker agreements are employment contracts. So all real estate employment agreements shall be written in clear and unambiguous language, fully set forth all material terms, including compensation, have a definite duration or expiration date, showing dates of inception and expiration, and be signed by all parties to the agreement. An employing broker shall not assign a listing agreement or other employment contract to another broker without the express written consent of all parties. So basically, it comes down to you need to have everyone signing to make sure that everyone is in agreement with what the contract says. So let's talk about employment agreements. Employment agreement is a contract hiring a broker to buy or sell real property for compensation or commission. Both listings and buyer broker agreements are employment contracts. Employment agreements are clearly written and they fully set forth the terms and inception and expiration date, and they're signed by all parties. Employment agreement assignment. So no assignment without written consent of all parties. So true or false? An employment contract is one that hires a broker to buy or sell real estate for compensation. This is true, right? So again, an employment contract is one that hires a broker to buy or sell real estate for compensation. That's true. Real estate employment agreements must be signed by all parties. This is also true, right? True. Real estate employment agreements must be signed by all parties. Buyer broker agreements are not considered to be employment agreements. False, right? So again, buyer broker agreements are not considered to be employment agreements. Buyer broker agreements are considered to be employment agreements. So here the key word is, it says are not. That is false. A broker may transfer listings to another brokerage company without the seller's permission. False. That is false. In order for you to take over your listings, what do you need? You need the seller's permission. The seller may not want you to take over the listings to another brokerage. Well, in that case, you have to get the seller's permission to do that. When a buyer broker agreement is taken by a salesperson, the broker must open a permanent file. True, right? The answer is true. So, again, when a buyer broker agreement is taken by a salesperson, the broker must open a permanent file. Now, if they close on a transaction, the broker has to keep it for 5 years. If it's a rejected offer, the broker has to keep it for 1 year. A broker may become a person's agent if no employment agreement is entered into. This is true, right? Again, a broker may become a person's agent if no employment agreement is entered into. The Arizona Association of Realtors Real Estate Agency and Disclosure Election Form creates an employment contract. This is false, right? Arizona Association of Realtors Real Estate Agency and Disclosure Form does not create an employment contract. Actions by licensees to collect compensation. An action for collection of compensation earned may be taken in the courts of Arizona. To begin the action, the licensee must prove that they were licensed at the time the claim arose. The commissioner shall not entertain complaints regarding purely civil disputes between licensees concerning the earning, splitting, or non-payment of compensation. Short title. So payment of commission to salesperson after license expiration. Okay, so we're back. I'm going to do actions by licensees to collect compensation. Short title is payment of commission to salesperson after license expiration or transfer of employment. The description of practice procedure is when a real estate licensee has rightfully earned a commission while in the employment of a broker. And in accordance with their agreement, that broker may pay the licensee, even though the licensee may have left the employment of that broker. The same finding applies to similar circumstances for an associate broker. A licensee may not be involved in the transaction after leaving that broker. So here's some Q&A. If a person was licensed when escrow was opened, but not licensed when the transaction closed, is he or she entitled to the compensation? Yes, right. So again, if a person was licensed when escrow was opened, but not licensed when the transaction closed, he or she entitled? Yeah, because they were licensed, right? So when they're licensed, and during escrow, they're still entitled to that compensation. Now, if they were not licensed and then entered into escrow, then they would not be entitled to the compensation. Okay, number 2, may a salesperson or associate broker sue a client directly for compensation without the broker joining the action or assigning the broker's rights to the salesperson or associate broker? No. So the employment agreements are contracts between the consumer and the brokerage company. All right, true or false? To collect a commission in court, the broker must first demonstrate that he or she was licensed when the claim arose. This is true. So again, to collect a commission in court, the broker must first demonstrate that he or she was licensed when the claim arose. So if you're licensed and you got the gig and you entered into escrow, you are entitled to compensation. The real estate department will arbitrate commission disputes between real estate brokers. False, right? This is false. So the real estate department will not arbitrate commission disputes between real estate brokers, right? This is for the brokers to handle or for the salespersons to handle. And if they don't handle it, then they take each other to court, civil court, and sue, and then they can sue each other. But the real estate department or the commissioner or the governor is not going to be involved with commission splits or commission disputes. After a salesperson's license expires, the salesperson may receive compensation for transactions entered into prior to license expiration. This is true. So again, after a salesperson license expires, right? So you have 2 years to renew your license. You don't do it, what happens? It expires. The salesperson may receive compensation for transactions entered into prior to the license expiration. So the question is, before it expires, do you get the compensation? Yes. After it expires, do you get the compensation? No. Without the broker joining the legal action, a salesperson has legal recourse against the seller who does not pay the broker commissions due under a listing agreement. This is false, right? So again, without the broker joining the legal action, a salesperson has legal recourse against a seller who does not pay the broker commissions due to under a listing agreement. So again, a salesperson doesn't have recourse without the broker, right? The broker has to join into this. So here's grounds for denial, suspension, or revocation of licenses. The statute lists over 30 reasons why a license could be denied, suspended, or revoked, including any violation of the commissioner's rules. In a disciplinary action, the licensee may enter into a consent order or is entitled to a hearing and may be represented by an attorney. The commissioner may issue a cease and desist order to someone found violating any act, practice, or transaction required by statute or commissioner's rules. Here's grounds for denial, suspension, and revocation of license. There's over 30 reasons, right? An attorney may represent licensees at a hearing. They could have a cease and desist order. So, what are some of the common violations that result in a license being suspended or revoked? Well, you can have undisclosed dual agency. That's a big one. So, if you're representing both parties and you don't tell both parties, you don't disclose that information, that's a violation. Employing unlicensed persons. If you are employing someone and they don't have their license and they're, describing contract law, well, that's another violation. If you're inducing a party to break a contract for the purpose of substituting another contract, that's a violation. Signing another person's name without that person's consent, that's a violation. Failing to exercise reasonable supervision over licensees, that's a violation. What amount of civil penalty may the commissioner assess for each violation of statute or rule? This is $1,000. So the amount of money that the commissioner can have licensees pay for each civil penalty, it would be $1,000 for each violation. A broker must have written permission to place a sign on an owner's property. This is true, right? So a broker has to have permission to place a sign. Arizona Real Estate Commissioner may issue a cease and desist order to anyone violating real estate statutes. This is true, right? So commissioner finds out that anyone's violating real estate statutes. The commissioner can send out what's called a cease and desist order so that they stop violating real estate statutes. A broker could have their license revoked for failing to supervise licensees. This is true, right? So, revoked, that's disciplinary action by the commissioner on the broker if they're not supervising their licensees properly. In a disciplinary action, a broker is not entitled to legal representation. This is false, right? In a disciplinary action, a broker is entitled to legal representation. For a violation of statute or rule, the commissioner may fine a licensee up to $1,000 per violation. This is true. So for a violation of statute or rule, the commissioner may fine a licensee up to $1,000 per violation. If a licensee enters into a consent order for violating a statute or rule, the licensee will not be fined. This is false, right? So if a licensee enters into a consent order for violating a statute or rule, the licensee will be fined. It's not be fined, they will be fined. Okay, according to ARS, Arizona Revised Statute 32-2163, an out-of-state broker may not perform real estate services in Arizona unless they enter into a written cooperation agreement with an Arizona broker who agrees to take liability for the out-of-state broker's acts. So cooperation with out-of-state brokers, you need to have a written agreement with an Arizona broker, and the Arizona broker has liability. So if you're dealing with a broker in Florida and they send you over a client and you want to deal with them, you must accept liability for that client. So may out-of-state licensees conduct real estate activity in Arizona on their own? No. There must be a cooperation agreement between an Arizona broker and the out-of-state licensee. What are the requirements of the cooperation agreement? So a list of the activities to be conducted by the out-of-state licensee, a statement that out-of-state broker agrees to comply with Arizona law and to submit to regulation by the ADRE, and a statement from the Arizona broker understands and accepts responsibility for the acts of the out-of-state broker. May an out-of-state broker list, market, or advertise Arizona properties? No, right? So again, if you have an out-of-state broker, they can't list, market, or advertise Arizona properties. You have to be licensed in the state you practice in. May an out-of-state broker place a sign on Arizona property? No, again, they can't list, they can't market, they can't advertise. If they're placing a sign that's advertising, they can't do that. May an out-of-state broker use a cooperation agreement as authority to sell, lease, rent, or exchange real estate to an Arizona resident? No. So, out-of-state broker, they can't use this cooperation agreement as authority to sell or do a transaction in real estate. Does the advertisement of real estate broker services through the internet relating to Arizona property constitute activity that requires an Arizona real estate broker's license? Yes. Must negotiations that occur in Arizona or with people who own Arizona property be conducted by the Arizona broker? Yes. How must funds taken by an out-of-state broker be handled? Well, they must be handled in compliance with Arizona statutes. An out-of-state broker may list and sell Arizona property without the assistance of an Arizona broker. This is false, right? So an out-of-state broker may list and sell Arizona property with the assistance of an Arizona broker. So out-of-state broker, you need the assistance of an in-state broker. If an out-of-state broker works under the Arizona broker, they must work under a written agreement. This is true, right? So an out-of-state broker working with an in-state broker, there has to be a written agreement. If an out-of-state broker works under an Arizona broker has liability for the acts of the out-of-state broker. This is true. So if you want to work with an out-of-state broker and you're an in-state broker, you have to accept the liability for the acts of that out-of-state broker. An out-of-state broker may place their company sign on an Arizona property. This is false. So an out-of-state broker cannot advertise a sign on an Arizona property. Money taken by an out-of-state broker must be handled in accordance with Arizona law. This is true. All right, so now we go on to restrictions on compensation. So real estate brokers may receive compensation from anyone and may pay their own licensed salespeople, and associate brokers. Other licensed designated brokers, real estate salespersons, and associate brokers may receive compensation only from their employing broker and may pay no one. It is illegal for anyone to pay compensation to an unlicensed person for activities requiring an active license. So if you want to get paid from real estate, you have to have what? You have to have a real estate license. Escrow companies may disperse commissions directly to salespersons or associate brokers only if instructed in writing by the designated broker in each transaction. An unlicensed person acting as a licensee is guilty of a felony. So again, an unlicensed person acting as a licensee is guilty of a felony. So if you practice real estate without a real estate license, you are guilty of a felony, class 6. It is illegal for a real estate licensee to receive compensation for negotiating loans secured with real property. ADRE substantive policy statement allows brokers to compensate former licensees for transactions the licensee was involved in while employed by the broker. It does not allow licensees to be involved in a transaction after leaving the broker's employment. So how brokers may pay. So you can pay a broker to broker. You can pay a broker to broker. A broker can pay their salesperson. So the broker can pay their salesperson, but a salesperson cannot pay another salesperson, right? You can only get paid from your broker. That's it. Salesperson may receive compensation money only from their employing broker. They cannot receive compensation from another broker. So it's illegal. Instructed by the designated broker. Each transaction. If your designated broker tells a title company that they can pay the licensee, it's okay, but it'll only happen per transaction. Each transaction that's required. So it's not like a blanket statement where your designated broker, can tell the title company that it's illegal for unlicensed persons to receive real estate money. Unlicensed persons receiving finder's fees or referral fees are committing a what? Are committing a felony, right? So you cannot pay somebody real estate money unless they have a real estate license. It's illegal for real estate licensees to receive compensation for negotiating loans. SPS 2005.08, it's okay to pay former licensees, not okay to be involved in former transaction. If a licensee changes brokerage firms, may the licensee's former broker pay the licensee directly for transactions opened prior to severance but closed after severance. Yes. Right. So here's the note. What does the independent contractor agreement say about this? And how much money? If a broker negotiated a purchase agreement between a buyer and a seller, and prior to closing, the broker's license was suspended, would the broker be entitled to compensation at closing? Yes. A non-licensed person who receives compensation for real estate activities is committing a felony. This is true. A real estate licensee may pay an unlicensed former client a fee for a referral of business to the licensee. This is false. So, a real estate licensee may not pay an unlicensed former client a fee just for a referral. An escrow company may pay a salesperson directly if the salesperson requested in writing. This is false, right? Escrow company may not pay a salesperson directly if the salesperson requested in writing. Has to come from who? Has to come from the designated broker. Real estate licensees may be compensated for negotiating loans on real property. This is false. After leaving a brokerage company and transferring to another brokerage, a salesperson may continue to be involved in transactions that were in escrow prior to the transfer. This is false. So, again, after leaving a brokerage company and transferring to another brokerage, a salesperson may not continue to be involved in transactions that were in escrow prior to the transfer. If a broker's license is suspended or revoked, any commissions earned prior to the suspension or revocation would be forfeit. This is false. You're still entitled to your compensations of anything prior to being suspended or revoked or anything like that. So unlicensed assistants, right? They may be employed by licensed salespersons or brokers. They may not perform duties that require a license. They may not be compensated on any basis that relies on the ultimate sale of a property. Title unlicensed assistants. Description of practices is in looking at the issue of unlicensed assistants, various aspects must be considered, including what activities the individual will perform and how the individual is paid. The definition of an unlicensed assistant is an unlicensed individual hired by an Arizona licensed real estate broker or salesperson as an assistant who is not engaging in any activity for which a real estate license is required. Definition: compensation means any fee, commission, salary, money, or other valuable consideration for services rendered or to be rendered, as well as the promise of consideration, whether contingent or not, due to ARS 32 2101/16. An unlicensed assistant cannot be compensated on any basis that relies on the ultimate sale or closing of a property. The employing broker or designated broker is responsible for addressing in its written policies and procedures who is responsible for hiring and compensating unlicensed assistants. The employing broker is responsible for all activities of licensed individuals within the brokerage pursuant to Arizona revised statutes and rules. All inclusions of the unlicensed assistant in advertising or marketing must indicate the individual as being unlicensed. An unlicensed assistant may, under the direct supervision of an Arizona licensee, perform the following tasks, which include but are not limited to personal errands of the licensee, clerical administrative tasks, including filing, copying, mailing, scanning, answering phones, forwarding calls, or transcribing callers' information for licensee. Using technology as a tool to complete tasks assigned by a licensee, which are not activities otherwise requiring a real estate license. Preparing marketing materials approved by the designated broker, delivering documents, assist at an open house with the licensee present, set or confirm appointments for a licensee to list or show property, a buyer with the loan officer, a property inspector to inspect a home, a repair maintenance person to perform repairs maintenance, an appraiser to appraise property, transmitting only instructions or information to clients, contractors, inspectors, appraisals. So an unlicensed assistant can do a lot of things, but they cannot explain any contract law, right? That's for actual licensed realtors or brokers. They can transmit instructions and they can unlock homes, unlocking a home for a licensee so that a licensee can show a client the property or preview the property. No discussion about the property. An unlicensed assistant shall not perform the following activities, right? These are something that they cannot do at all. They cannot originate documents. They cannot perform a walkthrough inspection or tenant vacant inspection. They cannot provide advice, pricing, or opinions of value to a consumer. They cannot provide advice or negotiate with anyone regarding a property or transaction. They cannot assist in preparation of documents with a consumer. They cannot hold or host an open house without a licensee being present. They cannot collect off or offer attempts or agree to collect rent. They can't assist or direct in the procuring of prospects calculated to result in the sale, exchange, leasing, or renting of real estate pursuant to ARS 32 2101, unless exempt under ARS 32 2121. Now, be advised that the exemption in ARS is very fact specific and limited in scope. They cannot attend closing with the consumer without a licensee being present. An unlicensed assistant may transfer monies or be a signatory on a property management trust account only when the unlicensed assistant is in the direct employ of the broker and is a bona fide officer, member, principal, or employee of the property management firm pursuant to ARS 32-2174C and the employing broker pursuant to ARS 32-2101. A non-licensed assistant is otherwise not permitted to withdraw monies from the broker's trust account pursuant to ARS. A person who performs acts that require a license under this chapter, other than a broker's or salesperson license, without being licensed as prescribed by this chapter, is guilty of a Class 5 felony, right? So if you want to hire an unlicensed assistant, you can. They can do a lot of things, but there's a lot of things that they can't do. Like they can't take money out of the broker's trust account because then they can catch a Class 5 felony, right? You don't want unlicensed assistants helping you but practicing real estate, because practicing real estate requires a real estate license and they can be subject to a Class 5 felony. Authority is under ARS, which defines activities of real estate broker, for which licensure is required pursuant to ARS 32-2122. So we went through a lot of things that unlicensed assistants can and cannot do. Right, they're going to be employed by a broker or a salesperson, and they cannot do anything that requires a licensed activity. Compensation is not based on the ultimate sale of a property, so you can't pay an unlicensed assistant based on selling the property. You have to pay them like a regular hourly wage. A real estate team is a group of licensees headed by a lead agent who works within a brokerage company. All teams' marketing advertising must include the real estate company name in a clear and prominent manner. A broker's policy manual should contain extensive policies relating to teams. Real estate team, there's going to be a lead agent within the brokerage firm. In the real estate team, marketing must include the company name and important policy manual item. You have to make sure you include that in your broker's policy manual. So may a team be a corporation or an LLC? No, it cannot be either, right? A team is just a group of realtors that got together. They're not a corporation, they're not an LLC. Must the team leader be an associate broker? No. The team leader doesn't have to be a broker. May a team leader receive commissions from the broker and subsequently pay individual team members their portion of the commission? No. All compensation for activities requiring a license must be paid by the broker. Compensation to an unlicensed real estate assistant may be based on the number of transactions closed. This is false, right? Compensation to an unlicensed real estate assistant cannot be based on the number of transactions closed. You have to pay them some sort of salary or hourly wage. But because that is for licensed realtors or brokers, they are paid on the number of transactions closed, right? Their commission split. Real estate teams are separately licensed real estate brokerage companies within a larger brokerage company. This is false, right? Real estate teams says, real estate teams are separately licensed real estate brokerage companies within a larger brokerage company. That's not true. Real estate teams are just a group of agents who got together and they work within the company, but they're not a separate brokerage company. They're all within the same company. Real estate team advertising must include the name of the brokerage firm in a prominent manner. This is true. So not only do you need to have the real estate company name, but you also need the real estate broker, right? The DB, designated broker's name, to be prominent. Unlicensed assistant may be employed by either the broker or a salesperson. This is true. A real estate team may be a corporation or an LLC. This is false, right? A real estate team, they are not a corporation or an LLC. They're just a group of agents who got together and who are doing transactions together. A team leader may be a salesperson or broker. This is true, right? You can have a team. You have your team. You have the group leader. They can be a salesperson. They can be a broker. It doesn't matter. They do not have to be a broker to be a team lead for a real estate team. The team leader is responsible for dispersing compensation to all team members. This is false, right? Who pays you? The broker. Who always pays you? Your broker. So you don't get paid by your team members. If there are other agents, they don't pay you. You always get paid by your broker. Your broker gets paid first, and they split their commission with you, with the salesperson. So for my company, it's like an 80-20 split. I split 20% of whatever, I make to the broker. ARS Title 32, Chapter 20. So we'll go over Real Estate Recovery Fund. This recovery fund was established to protect parties harmed due to reliance on a licensee, where the licensee either performed acts that require a license or committed fraud or misrepresentation while acting as a principal in the purchase or sale of real property. A lawsuit must be filed against the licensee within 5 years, and the commissioner must be notified of the suit within 45 days of commencing the action. Payment from the recovery fund will be made only by a court order and only after a civil judgment against the licensee that is uncollectible. The recovery fund is liable for a maximum of $30,000 per cause of action, and it's $90,000 per licensee. The licensee, broker, salesperson license is automatically terminated. So upon payment from the recovery fund. So if you do something and it causes harm and someone has to get paid out of the recovery fund, your license is now going to be terminated. The license may be reinstated after the licensee pays back all the money paid by the recovery fund plus interest, right? So again, the maximum, if you cause an action and it caused damage, it's $90,000 per licensee and it's $30,000 per cause of action. So say you did it as a salesperson or a sales agent, you caused incident to $90,000 of actions. Well, you got to pay back the $90,000 plus the interest, and then you can get your license back reinstated. Otherwise, it's terminated. Recovery fund fees. When originating a license, a broker pays $20. Salesperson pays $10. When renewing a license, if the fund has dipped below $600,000 on June 30th, the broker pays $20 and the salesperson pays $10. Immediately compensated by the recovery fund. This is false, right? So it's not automatically, there's a process to go through. The recovery fund is liable for a maximum of $30,000 per cause of action. This is true. So it's $30,000 per cause and it's up to $90,000 per licensee. So if your salesperson caused 3 causes of actions, you can only get up to $90,000 from that single licensee. The recovery fund is liable for a maximum of $90,000 for damages to a consumer due to one licensee's actions. This is true. So $30,000 is how much the recovery fund will pay out for one cause, and it's up to $90,000 due to one licensee's actions. If damaged in a transaction by another licensee, a real estate broker may make a claim against the recovery fund. This is false, right? So again, if damaged in a transaction by another licensee, a real estate broker may make a claim against the recovery fund. So the recovery fund is only for consumers. It's not for brokers or realtors to claim against the recovery fund. Brokers and realtors pay into the recovery fund to protect the public. We are to protect the public. We're protecting the consumer. It's not for the broker to make a claim against it to get money out of the recovery fund. When activating an original broker's license, the broker must pay $20 into the recovery fund. This is true. So again, when you activate an original broker's license, the broker must pay $20 into the recovery fund. If settlement is made from the recovery fund, the salesperson's or broker's license is automatically suspended until the fund is reimbursed by the licensee. This is false, right? It's not suspended, it is terminated, like the Terminator, right? So their license, if you cause action, severe action that causes the recovery fund to be made, the ADRE, the Arizona Department of Real Estate, will terminate your license. You don't get, it's not suspended so you can keep working. They will terminate that license. And it's it'll show when you look up the realtor on the ADRE website, terminated versus suspended. Terminated, there was a disciplinary action that occurred. Additional money would have to be paid to the recovery fund by licensees when renewing a license if the fund contains less than $600,000 on June 30th of any year. This is true. So again, additional money would have to be paid if the recovery fund by licensees when renewing a license if the fund contains less than $600,000 on June 30th of any year. So they try to keep like $600,000 in that recovery fund. And if there's not, then they ask for more money from the brokers and realtors across the state of Arizona. In order for a consumer to collect from the recovery fund, they must obtain a judgment against the licensee, and the judgment must be fully or partially uncollectible. The answer is true. So let's go over the unit summary to close out what we've covered. We've covered a real estate employment agreement is a contract hiring a broker to buy or sell real estate for compensation. Employment agreements must be in writing, contain all terms and conditions, have a beginning and ending date, and be signed by all parties. To begin a court action, to collect a commission, a licensee must show they were licensed at the time the claim for commission arose. Commission violations that could cause a broker to have their license suspended or revoked are undisclosed, dual agency, hiring an unlicensed person, forging another person's signature, and failing to exercise reasonable supervision over licensees employed by the broker. The commissioner may fine a broker up to $1,000 for each violation of statute or rule. So that means you really got to supervise your licensees. An out-of-state broker may not perform real estate services in Arizona unless they enter into a written cooperation agreement with an Arizona broker who agrees to take liability for the Out-of-State Brokers Acts. Real estate brokers may receive compensation from anyone and may pay their licensees and other brokers. Real estate salespersons may be paid only by their broker. It is a felony for an unlicensed person to receive compensation for services requiring a real estate license. Escrow companies may disperse commissions to salespersons only with written consent of the broker in each transaction. Unlicensed assistants may not be paid on any basis that relies on the ultimate sale of a property. All team advertising must include the name of the brokerage firm. Also, I would go and you need to put the designated broker's name on there as well. The maximum amounts that a consumer may receive from the recovery fund was $30,000 per cause of action and up to $90,000 per for one licensee. Okay, so next up, we're going to go over Unit 5, which is going to cover subdivisions and timeshares.